Chapter 2, Jurisdiction of the Chancery Court. Article I. Jurisdiction of the Chancery Courts generally considered. Section 16. Jurisdiction of the Chancery Courts of North Carolina. The article devoted to the history of the Chancery Courts of Tennessee plainly indicates the character and extent of their jurisdiction. The Act of 1782 vested the courts of equity in North Carolina with all the powers and authorities within their respective districts that the Court of Chancery, formerly held under the colonial government, used and exercised, and that were properly and rightfully incident to such a court. This act was continued in force in Tennessee by the deed of cession, by the territorial legislature, by the Constitution of 1796, by the Constitution of 1834, by the Act of 1835, by the Code of 1858 and by the Constitution of 1870. The question then rises, what were the powers and authorities used and exercised by the Chancery Court of North Carolina at the time of the American Revolution? This question can be answered only with approximate accuracy. No records, ordinances or statutes defining the jurisdiction of that court being in existence, so far as known. The court was established by the Lords Proprietors under the general power given them by the Great Charter of King Charles II. It was held by the Governor and his council, and there can be no doubt that its model was the Court of Chancery in England. The Supreme Court of North Carolina held, in the case of Griffin v. Graham, that the equity system of England was a part of the common law of North Carolina in force and use within its territory at the time of the American Revolution, which common law was, in 1778, declared by the legislature of North Carolina to be in full force within the state. Chancellor Kent, in Manning v. Manning, held that the English system of equity jurisprudence at the commencement of the Revolution formed an important and very essential branch of the common law. Section 17. Jurisdiction of the Chancery Courts of Tennessee. The same conclusion was reached by Judges Turley and White, in the great case of Green v. Allen, Judge White holding that the powers of our Chancery Courts are no doubt as ample as those of the Chancery Court of England, with no other difference except that which grows out of the difference of our institutions. Judge Green in Oakley v. Long, concedes to our Chancery Courts the jurisdiction which was exercised by the Chancery Court of England as a court of equity, and in Dixon v. Montgomery, he states that our Court of Chancery has jurisdiction in all cases where, in England, the Lord Chancellor in the exercise of his extraordinary jurisdiction, could have afforded relief. And Judge Cooper, in Lake v. McDevitt, says, the Chancery Court is vested with all the powers, privileges and jurisdiction incident to a court of equity by existing laws, that is, by the statutory and common law of the state. It is a superior court as contradistinguished from a court of peculiar, special and limited jurisdiction. It possesses, except where changed by statute, the jurisdiction which was exercised by the Lord Chancellor of England as an equity judge, denominated his extraordinary jurisdiction. In this case Judge Cooper recognizes the equity jurisprudence as a part of the common law of the state, thus concurring with the judges heretofore cited on this point. Section 18. Our Chancery practice founded on that of England. Not only are the principles and doctrines of the English Chancery Court in force in the Chancery Courts of this state, but, before the passage of the Act of 1801, we were governed by the English rules in Chancery practice almost exclusively, and our equity proceedings had the force and effect of proceedings in the English court. And as late as 1822, the rules adopted by the Supreme Court for the regulation of the practice of the Chancery Court provided that in all cases where the rules prescribed by Act of Assembly, or those rules heretofore adopted, do not apply, the practice of the Courts of Chancery shall be regulated by the practice of the High Court of Chancery in England. The U.S. Circuit Courts in this state, in their equity proceedings, are also governed by the practice of the English Chancery, as it existed in 1842. In Tennessee, while the pleadings and practice, in the main, conform to the pleadings and practice of the English Court of Chancery prior to 1875, there are, nevertheless, many material modifications, all of which will appear in their appropriate places in this treatise. Section 19, Powers and Jurisdiction of the Chancery Courts. It will thus be seen that both the jurisprudence and the practice of the English Chancery Court are in force in our state, except in so far as changed by our statutes and rules. So that, in summarizing the powers, privileges and jurisdiction conferred on our Chancery Courts by the Code, it may be safely stated that the powers and jurisdiction of the Chancery Courts of Tennessee, in and for their respective districts, are, except as changed by statute, identical in kind, and commensurate in extent, with the equity powers and jurisdiction of the High Court of Chancery in England at the time of the American Revolution. And it may be added, the statutory changes in the powers and jurisdiction of our Chancery Courts have greatly enlarged those powers and jurisdiction, and proportionately increased their efficiency and beneficence. Section 20. Statutory changes in the powers and jurisdiction of the court. As has been already stated, the statutory changes in the powers and jurisdiction of the Chancery Courts have mainly been additions, and not limitations. Jurisdiction means the authority possessed by a court to determine a controversy, and the powers of a court are its rights and ability to enforce its determinations. 1. The principal additions to the powers of the court are the following, given in order of time. 1. Power to order a bill to be taken for confessed. 2. Power to issue an execution to enforce a money decree. 3. Power to bring defendants before the court by publication. 4. Power to divest and vest title to property by decree. 5. Power to issue attachments to impound property. 6. Power to appoint a commissioner to execute a conveyance, release or acquittance, in the name of either the parties or of himself. 7. Power to appoint administrators ad litem when necessary in the progress of a cause. 2. The principal additions to the jurisdiction of the court are the following, given in chronological order. 1. Jurisdiction to impanel a jury to try an issue of fact. 2. Jurisdiction to proceed against non-resident and absconding defendants, by publication. 3. Jurisdiction to decree a divorce and alimony. 4. Jurisdiction to proceed in rem against the estates of non-residents by attachment and publication. 5. Jurisdiction to proceed against the real and personal property of non-resident defendants. 6. Jurisdiction to proceed by attachment and publication against the estates and persons of non-resident absconding debtors. 7. Jurisdiction to appoint an administrator, and wind up his intestate's estate. 8. Jurisdiction to keep corporations in the line of their duties, and to decree a forfeiture of their charters. 9. Jurisdiction over the persons and estates of idiots, lunatics and persons of unsound mind. 10. Jurisdiction to consent to, and decree, a sale of the property of infants and married women. If the court had inherent jurisdiction to do this, the statute certainly settled all doubts and enlarged that jurisdiction. 11. Jurisdiction to prevent the usurpation of office, and to declare an office forfeited. 12. Jurisdiction of all civil causes of action triable in the circuit court, except for injuries to person, property or character, involving unliquidated damages. Section 21. Effect of the Act of 1877 generally considered. In 1801, it was enacted that apostrophe after answer filed and no plea in abatement to the local jurisdiction of the court, no exception for want of jurisdiction shall ever afterwards be made. It has been uniformly held ever since the passage of this Act, that on failure of the defendant to object to the jurisdiction of the court before answering, the court had the right, and it was its duty, to determine the controversy, unless the matter was unfit for a court of equity. Under the operation of this holding, the Chancery Court had, for 75 years, been in the habit of entertaining demands, and causes of action, purely legal in their nature. The Act of 1877 is only one step further than the law was before, as Judge Freeman, in Jackson v. Nimmo, very conclusively shows. The Chancery Court has long had jurisdiction, in attachment cases, of debts or demands of a purely legal nature, except causes of actions founded on torts. Thus, it will be seen, the Act of 1877 is by no means as revolutionary as was at first supposed. Every enlargement of the Chancery jurisdiction for 500 years, in England and America, has been the signal for an alarm, but the enlargements have continued, until, both in England and a majority of the American states, The Chancery methods of pleading and the principles of the Chancery jurisprudence have, in a large measure, superseded the unbending formalities and the harsh doctrines of the common law. The Act of 1877 goes far to settle the ancient controversy between the Chancery and the common law courts, with respect to the boundary line between their respective jurisdictions, and it includes not only the disputed territory, but also all the territory adjacent thereto, within the concurrent jurisdiction of the Chancery Court. In the English Judicature Act, passed in 1873, it is provided that generally, in all matters in which there is any conflict or variance, between the rules of equity and the rules of the common law with reference to the same matter, the rules of equity shall prevail. The effect of this provision is to make the rules of equity supreme, in all litigation, in all the courts of England. It is believed the Tennessee Act of 1877 has the same effect in all common law rights of action sought to be enforced in Chancery, when the jurisdiction of a court is enlarged. The new subjects of jurisdiction should not be treated as aliens, and discriminated against, nor should the parties to such suits be held in disfavor, or denied any equitable right, benefit or privilege, accorded by the court in the ordinary exercise of its jurisdiction. The Act of 1877 was manifestly intended to enlarge the jurisdiction of the Chancery Court as a court of equity, and not to make it, as to this enlargement, a mere common law court, and hence, in all suits brought under the Act of 1877, the pleadings, practice and principles of equity jurisprudence will control. Section 22. Classification of matters of equitable jurisdiction. The importance formerly attached to a proper classification of the subjects of equity jurisdiction no longer exists in this state, and it is now immaterial whether the matter in controversy is within the equitable or the statutory jurisdiction of the court, and if within the equitable, it is unimportant whether the jurisdiction be exclusive or concurrent. As a result, all the abstruse learning in the books on the lines of demarcation between the different grounds of jurisdiction has ceased to be of much practical value. The legal niceties, the complex technicalities and the dialectical discriminations on the subject of jurisdiction, with which the great jurists of England and America wrestled in the last 5 centuries, no longer perplex either the student or the practitioner in this state. For convenience of consideration, the jurisdiction of our Chancery courts, as now constituted, may be divided into 1. The equitable, or inherent, and 2. The statutory. 1. The equitable, or inherent, to include all of those matters, whether purely equitable in their nature or having characteristics both equitable and legal, jurisdiction over which is derived exclusively or chiefly from their inherent powers as courts of equity, and 2. The statutory, to include all of those matters, whether equitable in their characteristics or purely legal in their nature, jurisdiction over which is derived exclusively or chiefly from our statutes. Article 2. The equitable, or inherent, jurisdiction of the Chancery Court. Section 23. The equitable, or inherent, jurisdiction of the Chancery Court generally considered. The jurisprudence and procedure of the Chancery Court constituted a part of the law our ancestors brought with them from England, when they founded the colony of North Carolina. When that colony became a state, this jurisprudence was recognized, and its administration provided for, in its constitution, and in 1782, its legislature conferred this jurisdiction upon the courts. Tennessee being then a part of North Carolina, that jurisprudence became a part of our law, and, when we became a state, both the deed of cession and the act of admission by Congress, made the laws of North Carolina our laws, until we saw fit to change them. In our first, and in all subsequent, constitutions, the jurisprudence and procedure of the Chancery Court were fully recognized, and their administration abundantly provided for. While the procedure has been modernized, simplified and improved, in many particulars, as already fully shown, the jurisprudence has in no particular been changed, except in so far as it has been extended and enlarged on the lines of its legitimate development. This original jurisdiction, thus derived, through the colony and state of North Carolina, from the equity jurisprudence of England, is called the inherent jurisdiction of the court, to contradistinguish it from the statutory jurisdiction, and it is to this original and inherent jurisdiction that our statute refers when it says, "The Chancery courts shall continue to have all the powers, privileges and jurisdiction, properly and rightfully incident to a court of equity, by existing laws." The inherent powers, privileges and jurisdiction of our Chancery courts, within their respective local and personal jurisdictions, are identical in kind and commensurate in extent, with the equity powers, privileges and jurisdiction of the High Court of Chancery in England, at the time of the American Revolution. The Chancery Court is a superior court of general original jurisdiction of all cases of an equitable nature, where the debt or demand exceeds $50 and every matter of equitable cognizance above said amount is presumed to be within its inherent jurisdiction as a court of equity. Section 24. The equitable, or inherent, jurisdiction generally stated. The whole inherent jurisdiction of the Chancery Court, aside from its injunctive powers, may be briefly summed up in these four propositions. 1. If a lawful and equitable contract be the subject matter of the suit, all the court can do is, 1. To equitably enforce the contract, or, 2. To award compensation for its breach, or, 3. To require the party in default to do such act relative thereto as he, in good reason and good conscience, ought to have done without suit. 2. If there be no contract, or the contract be inequitable, and the parties disagree as to their rights and duties, all the court can do is, 1. To require the party in default to do, or refrain from doing, what good reason and good conscience require, or, 2. Where injury has been done, to make the defendant atone therefor. 3. If any of the parties are under disability, and, 1. Their interests will be promoted by a sale of their property, or by a conversion of their money into other property, or by using a portion or all of the corpus of their estate for their maintenance, education or support, or, 2. If their rights need protection or enforcement, on the application of a guardian, or next friend, the court will 1. By decree do for them what they in reason and conscience would themselves have done if under no disability, or, 2. Will require the parties who are sui juris to do to or for those under disability, what in good reason and good conscience, they should have done without suit. 4. If the parties are sui juris, whatever they consent to during the progress of the suit will, if violative of no law, be binding on the court, and if it is to the interest of an infant or lunatic party to join in any lawful consent, and the state of the pleadings permit, the court can consent for such infant or lunatic, and, generally, where there is consent, the parties bind the court, and where there is no consent, the court binds the parties. Section 25. The equitable, or inherent, jurisdiction, specially stated. The equitable or inherent jurisdiction of the Chancery Court includes all cases of an equitable nature, where the debt or demand exceeds $50. These cases include the following: 1. All suits resulting from accidents and mistakes. 2. All suits resulting from frauds, actual, and constructive. 3. All suits resulting from trusts, express, constructive, and resulting. 4. All suits for the specific performance of contracts. 5. All suits for the reformation, re-execution, rescission, and surrender of written instruments. 6. All suits for an accounting, and for surcharging and falsifying accounts. 7. All suits between partners, and to wind up an insolvent partnership. 8. All suits for the administration and marshalling of assets. 9. All suits for subrogation and substitution. 10. All suits for the enforcement of liens created by mortgages, deeds of trust, sales of land on credit, or other equitable considerations. 11. All suits by married women against their husbands, except for divorce. 12. All suits against married women and minors in reference to their estates, not cognizable at law. 13. All suits by wards against guardians, executors, administrators and others, where an accounting, or surcharging or falsifying an account, is necessary. 14. All suits for an apportionment and contribution. 15. All suits for the marshalling of securities. 16. All suits for relief against forfeitures and penalties. 17. All suits for the redemption of land or other property. 18. All suits to have absolute deeds or bills of sale declared to be mortgages. 19. All suits for the construction and enforcement of wills and trusts. 20. All suits to obtain a set-off against a judgment in favor of a non-resident or insolvent. 21. All suits for the discovery and perpetuation of testimony. 22. All suits to compel claimants to interplead. 23. All suits for equitable attachments and receivers. 24. All suits where an exiat publica is sought. 25. All suits where an injunction is a substantial part of the relief sought. 26. All suits to remove clouds and quiet titles. 27. All suits for the establishment and execution of charities. 28. All suits for a new trial after a judgment at law. 29. All suits to have void judgments so declared, and to avoid voidable judgments. 30. All suits to execute decrees, and to impeach decrees and judgments. 31. All suits to prevent the doing of an illegal or inequitable act to the injury of complainant's property rights, or interests. Quia timit. 32. All suits for the exoneration or protection of sureties. 33. All other suits where the defendant has done, or is doing, or is threatening to do, some inequitable act to the injury of the complainant, and there is no adequate remedy therefore in any other court. Article 3. Statutory jurisdiction of the Chancery Courts. Section 26. Statutory jurisdiction of the court generally considered. With perhaps the single exception of the Act prohibiting interlocutory injunctions against the collection of state taxes, all of the statutes now in existence relative to the powers, privileges and jurisdiction of the Chancery Court are either declaratory or augmentative, as has been shown in a preceding article. The statute declares that the court has all the powers, privileges and jurisdiction properly and rightfully incident to a court of equity, by existing laws. The effect of this statute is to make the inherent jurisdiction of the court, in a sense, also statutory. The statute further declares that the court has exclusive original jurisdiction of all cases of an equitable nature, where the debt or demand exceeds $50. Unless otherwise provided by the statute. The court has no jurisdiction of any debt or demand of less value than $50, except upon an ejectment bill to recover land, or on a replev in ordinance bill, or on a bill to aid a judgment creditor, or on a bill to enforce the statutory rights of a purchaser of realty at a tax sale. The court cannot enforce a vendor's lien when the amount of the demand is less than $50. The statutory jurisdiction, while including matters also belonging to the inherent jurisdiction, may for convenience be divided into 1. Jurisdiction concurrent with the county court, 2. Jurisdiction concurrent with the circuit court, and 3. Jurisdiction exclusive of all other courts. Section 27. Jurisdiction concurrent with the county courts. The Chancery Court has jurisdiction concurrent with the county court. 1. Of the persons and estates of idiots, lunatics, and other persons of unsound mind. 2. Of the persons and estates of infants, and of the appointment and removal of guardians. 3. Of suits for the partition, or sale, of estates, by heirs or tenants in common. 4. Of suits for the sale of a decedent's land at the instance of his personal representatives or creditors, if the personal property is insufficient to satisfy the debts of the estate. 5. Of suits for the allotment of dower. 6. Of suits for the appointment of an administrator of a decedent's estate, when 6 months have elapsed since his death, and no person will apply to the county court, or can be procured, to administer in the usual way. And 7. Of suits to enforce the payment of legacies and distributive shares. Section 28. Jurisdiction concurrent with the circuit courts. The Chancery Court has jurisdiction concurrent with the circuit court in the following cases. 1. Of suits for divorce and alimony. 2. Of suits for the partition, or sale, of estates by heirs or tenants in common. 3. Of suits for the sale of a decedent's land at the instance of his personal representatives or creditors, if the personal property is insufficient to satisfy the debts of the estate. 4. Of suits for the allotment of dower. 5. Of arbitration and agreed cases. 6. Of suits for the abatement and recovery of usury. 7. Of suits to enforce the payment of legacies and distributive shares. And, under the Act of 1877, the Chancery Court has jurisdiction, concurrent with the Circuit Court, in the following cases: 8. Of all suits to recover money due for work or labor done, or services rendered, or for the hire, rent, use, price or value of property, real or personal. 9. Of all suits to recover money expended for the defendant's use and benefit, or at his instance and request. 10. Of all suits to recover money the defendant has received from or for the complainant, without the right to retain it against him. 11. Of all suits to recover money agreed, or adjudged, to be paid. 12. Of all suits to recover money due on any contract, express or implied, or due on any judgment or award, or lost at gaming. 13. Of all suits to recover penalties, or liquidated damages, or damages liquidated or unliquidated, for breaches of contracts, expressed or implied, or for breaches of any obligation or legal duty. 14. Of all suits to recover damages in all other cases, except damages for injuries to person, property or character, involving unliquidated damages. 15. Of all suits to recover land, or any interest therein, or any rent or profit thereof. 16. Of all suits to recover specific personal property. 17. Of all such special actions and proceedings as ejectment, forcible entry and detainer, replevine, detinue, mandamus, habeas corpus, summary proceedings by motion, and proceedings to change names, and to legitimate and adopt children, and 18. Of all other civil causes of action triable in the Circuit Court, except for injuries to person, property or character, involving unliquidated damages. The Chancery and Circuit Courts have also concurrent jurisdiction of all suits in the name of the state against corporations, and to prevent the usurpation of office. And 20. Of all suits commenced by attachment against the property of the defendant. 21. Of all suits to enforce mechanics' liens, landlords and furnishers' liens, liens on boats, liens of cotton sellers, liens for wharfage, liens of employees of corporations and partnerships, liens of farm laborers, liens of contractors and laborers on railroads, and liens on personal property. 22. Of all suits brought in the name of the state or county to enforce liens for taxes, and 23. Of all appeals from the judgment of the county court on an account stated by the county court clerk with an administrator, or executor. Section 29. Act of 1877, specially considered. The Act of 1877, ch. 97, was at first regarded with disfavor by the courts and the bar, and even its constitutionality questioned. When recognized at all, it was done grudgingly, and attempts were made by both judges and solicitors to limit its application, and construe it as though it made a law court out of the Chancery Court. But the Act gained steadily in favor, its constitutionality was recognized, and its wisdom and usefulness appreciated. It is being more and more liberally construed, its far-reaching and beneficent effects are more and more fully understood, and its extensions of remedial powers and processes more and more generally appreciated and applied. This Act places at the disposal of the Chancery Court all the powers and jurisdiction of the Circuit Court, in civil causes of action, except a few involving unliquidated damages, so that when a suit is being tried in Chancery, the Chancellor has at his disposal all the weapons and machinery of justice contained in the armories of the common law as well as those in the armories of equity, thus enabling him to do full, complete and adequate justice in the suit before him, unhampered by the formalities and technicalities of the common law, and unhindered by the former statutes conferring exclusive jurisdiction of common law matters upon the circuit courts. The Act of 1877 did not carry the Chancellor into a law court to try the lawsuit, but carried the lawsuit into the Chancery Court to be heard by the Chancellor, and clothed him with all of the powers of the Circuit Court in addition to those of the Chancery Court. so as to enable him not only to administer the law applicable to the case, but at the same time, to apply any powers or principles of equity necessary to determine all the questions involved in the controversy, and render any further litigation not only unnecessary but improper. While the maxim, when Chancery has jurisdiction for one purpose it will take jurisdiction for all purposes, has always been a favorite one, nevertheless the court was formerly so hampered by not having a jury of its own to determine a controlling question of fact when the evidence was conflicting and the credit of witnesses to be weighed, or to assess unliquidated damages, that it often, perhaps too often, after deciding the equitable matters in controversy, refused to go further and remitted the complainant to the courts of law in order to obtain the remainder of the redress he was entitled to. But now, clothed with law powers by the Act of 1877, and having full power to impanel a jury of its own, our Chancery Court can give full effect to the said maxim, and, in one and the same suit, determine every question of equity, law or fact involved, including unliquidated damages where such damages are incidental to the main object of the suit. Section 30. Exclusive statutory jurisdiction of the Chancery Court. The Chancery Court has exclusive statutory jurisdiction of the following suits, some of which, however, belong, also, to its inherent jurisdiction. 1. Of all suits to aid judgment creditors, when the property of the defendant cannot be reached by execution. 2. Of all suits to set aside fraudulent conveyances, and subject the property so conveyed to the satisfaction of complainant's debt. 3. Of all suits to subject the property of corporations to the payment of their debts, when the corporate franchises are not used, or have been granted to others, in whole or in part. 4. Of all suits relating to controversies between the state and incorporated companies, their stockholders and creditors, growing out of the internal improvement laws of the state. 5. Of all suits to enforce foreign judgments against the property of the non-resident defendant when the creditor has exhausted his legal remedy. 6. Of all suits to sell the property of infants and married women, for their support, education and maintenance, and when manifestly for their interest. 7. Of all suits to partition, sell and reinvest the property of lunatics, when for the manifest interest of the lunatic or his family. 8. Of all suits of an equitable nature, where the debt or demand exceeds $50, unless otherwise provided by the Code of 1858. Each of these suits is considered at large, under appropriate headings, in subsequent sections.